going to be talking about mostly the parameters of all of that, right? Tenants have a right to counsel. Not every tenant has in court. In fact, as a lawyer, why is that? What are folks doing about that? And, where is this all headed, right? How are we gonna reach the day where we're gonna have a fully implemented right to counsel? But hopefully, yes, Ms. Springer, this is right here, thank you. Hopefully we'll have time during the 2 hours to not only talk about right to counsel implementation, that's gonna be the most of it, but I do wanna get to broader topics such as social housing, CSS, Community Service Society has done some very interesting studies about that, I'm excited to talk about that. And I do want to talk about the day when summary proceedings will be done and over, right, Professor Scherer? Did you disappear? We're gonna be done with them? Okay. And I'm sure we're gonna hear from Professor Scherer about what that could look like, right? What the blueprint for that will be. Okay, so let me start off with introducing the panelists. So in alphabetical order, we have our council member, Sean Earl. Very good to have you here, council member, this morning. New York City Council, District 7. There are full bios in the material, so I'm just going to kind of like say the names and the titles, but I invite you all to read fully about each of our panelists. Formerly a NILAC tenant attorney, right? We're going to have the Honorable Jack Stoller, who's the supervising judge of the city's housing court, hopefully join us soon. Ms. Lauren Springer, Right to Counsel New York City Coalition Steering Committee and tenant leader for Catholic Migration Services. Good morning, Ms. Springer. We have Oksana Mironova, who's a housing policy analyst with the Community Service Society. Good morning, Ms. Mironova. We have Matthew Trupp, who is the Director of Housing of the Legal Aid Society of the Civil Practice. Good morning, Mr. Trupp. And we have Professor Andy Scherer, who is the Professor of Law and Policy Director of the Wilf Impact Center for Public Interest Law at New York Law School. Good morning, Professor. One logistical point, there is a Google Doc that any of you can access to drop questions. Just so you know, right now I have 3 questions total. So feel free to drop in questions there, even as the panel is going along. And as for the panelists, I have my own set of questions, and then I guess I will weave in questions that I see from the audience, as we're going along. Okay. So I think we've gotten all the housekeeping out of the way, so let's begin. I have questions for each of you panelists, but I want to start with kind of 2 broad questions that I want to present for the whole panel. So for these first 2 questions, any of you who would like to chime in, please do. As many of you who would like to chime in, please do. Okay. In 1997, 25 years ago, a report by the court system noted that although the housing court was established in 1972 to enforce state and local laws regulating housing maintenance standards, quote, the overwhelming number of non-payment proceedings, often involving self-represented litigants, has shaped the character and operation of the court so that its primary function has been to process the large volume of eviction proceedings. That was the reality already as per a court system report in 1997. Fast forward to 2019. Court statistics show that out of nearly 200,000 cases filed in the housing court, 93% of those cases were eviction cases, and 7% of those cases were cases in which tenants are suing their landlords for repairs and for harassment. So, given what we have all seen in the 50-year history of the housing court, a court that was created for the main purpose of code enforcement, for tenants to get their repairs, and how it has shifted to almost entirely an eviction court. My question for the panel, and good morning, Jack Stoller.
Good morning, apologies for being late.
Has just joined us. So my question for the panel is, what do you all make of the shift of the housing court from originally code enforcement to evictions over time?
I probably have the longest involvement of anyone on the panel with housing court. I started practicing in 1978 and have been in and around it for the last 45 years, so 90% of the history. And the only thing I would disagree with, Louise, about the premise is that there was a shift. When I started in 1978, it was all about evictions and not about repairs. And I see Annie Rand shaking her head to agree with me. It was slightly longer than I was involved. It was created to be an eviction court. It was called a housing court. The legislature gave lip service to the idea that it was going to be about code enforcement, but from day one, it was always a collection agency court. That's what its function was. And incidentally, and on the side, some ability to bring actions against landlords and tenants. So.
Let me ask you really quickly, Professor Scherer, because the court system itself, the unified court system in its 1997 report, is saying what the court was created for. And the court system is saying that the main focus of the court was code enforcement. So, am I hearing you correctly that what happened here? The court was saying something, but it was in fact doing some other thing?
I think that's exactly what happened. I think the legislature set up legislation calling for a court to deal with code enforcement, but in fact, that was never the primary focus of the court. It just never was, and I don't know why, they went to the trouble to actually kind of dress it up in legislation that made it seem like it was going to be a court for code enforcement. And maybe it was, I've been around a long time and not that long, maybe it was a bit of an improvement over what was there before in terms of multiple forums that you would have to go to try to deal with code enforcement. But really from day one, so there was a real discrepancy between what was articulated in the legislation and what actually happened on the ground.
Anyone have a response for Professor Scherer here?
Hello. No, I just wanted to support what Annie's saying. So it's the coalition's position that the housing court is working the way that it's designed to. So it is an eviction mill. You have it, and historically it's been weaponized and used as an instrument of displacement, gentrification, homelessness, and it's targeted. I don't know if that's the right word or if that's a loaded word, but it really, most of these eviction cases were brought against people of color, against female-headed households. So it is working the way that it was designed to.
I don't disagree with Professor Scherer. One thing I will say is I think, and you would know better than I would, so I'll defer to you. I think that part of the idea was that tenants would withhold rent and then litigate the issues in non-payment cases. So it is possible for summary proceedings to be a place where code enforcement goes on. Of course, that doesn't happen, and it takes away from your point, and I actually agree with it. I mean, certainly by the time I started, which was after you, not far after. I've been in the court a long time. Yeah, it has been predominantly a case about summary proceedings, a court about summary proceedings.
I would just add also that, it's a system problem, right? That's what we have. We have a system that incentivizes bringing these types of cases, creating the volume that makes it so that housing court has the pressure to go through those cases and not have enough judges or court parts to deal with conditions cases. It's a disappointing thing that, we haven't made as much progress, I think, as everyone would have hoped at this point, that we're still talking about this years and decades later, that this is still where we are. But, we have to start in certain places. We've made some improvements, right? We've changed laws. But I always go back to, after HSTPA was passed, a landlord's attorney came out to me. And they said, well, now we're just not going to do repairs because there's no incentive. And that, it's astonishing to me. Like, HSTPA did so many great things, and that was that landlord's attorney's takeaway. And I think until, eviction, which is a trauma that no one should have to go through, but it is a trauma, until that system is no longer here, we have to deal with some of the realities and keep fighting, right? We keep fighting, we don't just stay and say this is how it is. we keep fighting, but until the system changes, there's not going to be sort of these systemic changes. And it really perpetuates all the systemic issues that we see with our clients, people, as you said, who are really the ones suffering from this kind of system. So I don't think there's an answer other than hopefully one day maybe these eviction courts or eviction process will no longer be what it is. But for right now, we keep fighting to change laws to make it more, to make landlords feel some of the financial parts of not complying with the law. But we still need to do better. Like, we're not anywhere close to where we need to be.
On the systems front, I think even if we take a step back and make the assumption that the idea that housing court was set up to give a leg up to tenants in conditions cases, like we take that as a base level, like the 1973 legislature was really like the pro-tenant, they're our best friends. If you launch something into a legal framework, a governance framework that is already unjust, it will replicate and reproduce the injustice. So with a housing court that is plopped up into a broader system where tenants have way less power, that it will just reproduce those power relationships, which is why interventions, right, like right to counsel, like the 2019 rent laws are so important, because you're trying to balance the scales a little bit and trying to make it easier for tenants to use this framework to their benefit.
I agree with that position, and I think that what the Right to Counsel has done has sort of, in a way, brought life to the intent of tenants being able to bring and assert their rights in court. And I think that's where, for many years before the Right to Counsel was passed, you see this power dynamic where landlords were just very well represented, 98% of them. And you have tenants that before Right to Counsel was less than 1%. And so it only perpetuates that dynamic and makes it such that we are focusing more on non-payment proceedings because it favors the landlord's interest more than it does serve tenants. And as we see with Right to Counsel, is that when a tenant is represented in housing court, they're actually asserting their rights now through their defenses. They wouldn't normally bring a claim to housing court, but for a landlord coming and suing them. At which point, that's where they assert their defense for repairs and their defense for other things. And I think it's interesting to see how Right to Counsel has now given us the opportunity through defenses to make their voices heard, which in a way brings back life to the intent of the law, if it is assuming for us the assertion of tenant rights, not the other way around.
And the other thing with Right to Counsel is that it empowered tenants not just with respect to the housing court proceedings, it also empowered tenants in terms of just fighting back, forming tenants associations and just using their collective power to push back against some of the practices that landlords were engaging in, whether it's lack of repairs or tenant harassment and whatnot.
And as Judith said before, Right to Counsel is just one component of all this. One thing that I think we haven't touched on yet is that the affordable housing crisis that New York has right now. We need more affordable housing. We need more benefits, vouchers, as was indicated as well, in order to make it more affordable. We're in one of the most expensive cities in the world, but these laws and a lot of it were designed to maintain affordable housing, and it's not happening. So that's not just like a lawyer issue, right? That is a system issue with legislatures, with advocates. Like, we all have to come together and keep fighting to develop more affordable housing, to keep more affordable housing. Because if there was more affordable housing, maybe there would be a reduction in the number of eviction cases that would drop, maybe. I mean, there's lots of things that go into that. But that's just one thing that we need to do. In addition, this is an access to justice issue. Most people do not have the type of access that they need to empower their communities or themselves to be able to bring the type of litigation that might be needed to enforce code standards, to understand the process, to have lawyers to be able to help do these cases so that we can actually make sure that people are living in habitable, affordable housing, not just affordable housing, it needs to be habitable. Those are important things that, you know, it comes down to, we need to invest in doing these things, and hopefully we'll get there, but we're not there right now. That's why we're talking about this. That's why we're still at this crisis and crossroads of right to counsel.
And one thing, sorry, in terms of when you talk about affordable housing, we just qualify that with truly affordable housing.
Yes.
Because a lot of housing that's called affordable is not affordable.
Professor,
Yeah, I just want to pick up on a couple of the great things that were just discussed. I think, you know, Judge Stoll was right that there was, that was the moment of the warranty of habitability. It was actually, believe it or not, it was not that many years before that, that the whole idea that you could withhold rent in exchange for, and get an abatement of your rent because of the conditions was a novel idea. The legislature had yet to pass it. It was being done as a matter of common law. The judges were making decisions. So it was the moment for the warranty of habitability. The problem was, as people are pointing out, they set up a system where there was no right to counsel. So you had, you know, teeny courtrooms not really meant to accommodate litigants, where you had you know, judges who weren't really judges, they were hearing officers. So the whole system was set up in a way to really defeat the idea that it was supposed to be premised on. So, and it's the system, I think, that we need to blame for that.
One thing I just want to add on to what was said before, when you're talking about using like HSTPA and access to counsel with regard to this. 2019, the Housing Stability and Protection Act was enacted, and I think a really big change that, among the many big changes that law made, was to take away the benefit that landlords got from an eviction. Landlords weren't allowed to deregulate or stabilize apartment, and they couldn't even raise the rent. And that was around a couple years after the City Council enacted the access to counsel law. I don't know if correlation is causation, but there has been a noticeable drop in summary proceedings filed, eviction proceedings from 2019. The pandemic obviously creates an aberrational situation, but the number of cases, eviction, non-payment, and holdover being brought from 2019 to 2022 and 2023 is substantially less. Now, maybe that's because landlords are figuring that with access to counsel, for previously frivolous cases they could have brought, they might have slipped by, wouldn't get by. Maybe it's because there's no more advantage to trying to get a vacancy. And maybe it's some other reason. But to the extent that what the panelists were talking about, closing the gap, that trend is something that can go in the direction that you're talking about.
Yeah. It's interesting you say that because right now it feels like because they grew up with the pandemic and now they're coming up with a bang. It feels like an
It does feel like
force,
that.
the way that they're coming back. But what you're saying is that
It's
perhaps
not,
once it stabilizes, it's going to be less than pre-pandemic.
it's I don't have the exact data in front of me, but it's much less than 2019 right now. I mean, it's more than half, but it's like
It was 200,000 in 2019.
well, the number of index numbers is always misleading because a lot of people buy index numbers and nothing happens with them in terms of the number of cases that come in court, the number of court appearances, like by every measure, it's less now than it was before the pandemic. When the law said you couldn't do anything in housing court, it does feel like more than when we couldn't do anything. But the pandemic was obviously a very sui generis event, and the trend, and I think that the trend is accelerated by access to counsel by the HSTPA also.
Yeah, so this is, I'm in the process of looking at this data now, so I'm gonna talk about research I haven't fact-checked, which is always a terrible idea. But I think I agree with the judge's assessment that it seems like the filings will probably settle out at a point that is going to be lower than it was in definitely 2017, 2018, but even compared to 2019, which was like a really remarkable year because we passed HSTPA. It's still too many filings. I mean, it's still hundreds of thousands of people whose lives are getting offended. But yes, I think that there's absolutely proof in the data that the HSDPA, as it was written, and Brexit Council are working, which is a huge testament to all of you.
And Oksana, correct me if I'm wrong, but didn't the numbers of filings go down between 2017 and 2019 before HSDPA, but it's the beginning of really the buildup of the Rights Council?
Absolutely, yeah, both filings, which shows changes in landlord behavior, which is really important. I think that maybe it was Judith that was talking about evictions, landlords using evictions to kick out rent-stabilized tenants, basically. So I think those types of unjust evictions are started declining in 2017 and then declined even more. So yeah, both landlord behavior as presented by eviction filing data, but also evictions themselves, where tenants are actually able to fight back if they have a lawyer. That was definitely happening before 2019.
All right, that was question one. We're underway. Lauren, you mentioned, you introduced the topic of who we're talking about when we're talking about who gets sued in housing, right? Who are these folks? And so I want to ask the panel a question to dive a little bit deeper into that, right? According to city and state statistics, rent arrears applicants by gender are majority female, by ethnicity, majority Latinx, and by race, majority Black. Individuals and families in New York City shelters are overwhelmingly Black and Latinx. It is very safe to say that housing insecurity and homelessness in New York City is predominantly an issue faced by Black and Latinx families, especially those with female heads of household. Now the question to the panel is, do these statistics respond to larger societal factors separate and apart from the housing court? Or has the housing court itself played a role in shaping this reality?
I can speak to that. What's happening in housing court is clearly related to societal issues that have predated me and have really been pervasive for years. Women have long borne the brunt of this housing practices, especially. The unfortunate truth is that women face higher poverty than their male counterparts, and women of color face more, are well represented among women in poverty especially. I mean, when you just think about until 1968, the Fair Housing Act, single mothers were excluded from accessing apartments and were regularly evicted from their NYCHA complexes. For me, this is especially personal. When I was 9 years old, I came home to find my mother holding an eviction notice at the kitchen table. And, those moments, when you're 9, you can't fully appreciate what an eviction really means, because, you can take shelter with your neighbors or your grandparents' house. And my mom, of course, masked it in such a way that I thought I was just going to my grandparents for fun. But it's when you get older, and it's why I became a tenant rights attorney, to keep families in their homes. Because I know what families are going through. It is something that we have seen separate and apart from the housing court system. And that's why in the city council, my job is to make sure that we're expanding free legal services so that we are catching up.
You had a question, I think it was a two-part question. Are these societal problems, or does housing court contribute? And I think the answer is both. Housing court, I think, is downstream of a lot of problems that society hasn't solved. Structural racism, wealth inequality, our very inadequate mental health provisions in this society. And in addition to that, the court commissioned a report in 2020 about racism in courts in general. And I was part of the subcommittee that drafted a report for housing court that made it onto that report. And we talked about how the kinds of racism that we see in society that get permeated through the court system, how that's affected in housing court. When we talk about people of color who are predominantly the tenants, how that affects things like implicit bias, how that affects things like resource allocation, so that we get, what they call assembly line courts or these mill kinds of courts, and how that the fight for resources for courts like that has an effect on justice and the way that it's meted out. And to combat against that, it involves both working outside housing court in terms of dealing with the various problems that that pre-existed housing court, but also dealing with that at the court level itself. The Jay Johnson report, as it's called, had a lot of recommendations in terms of trainings which are being implemented, but also you talk about the kinds of facilities for housing court compared with the kinds of facilities that you might get with, like, say, the commercial division. You talk about staffing, you talk about caseloads, number of calendars per day, how that all has an effect on implicit bias, on the way that people are treated, on the way justice is meted out. And so the answer is both, and working toward that is a work in progress and something that not only the court system wishes to work on, but also wants to get input from anyone who wishes to give it. I would add that I have been contacted by people like tenants attorneys, for example, who want to give trainings on this subject. I have program trainings with tenants attorneys on this. It doesn't just have to be tenants attorneys, it could be anyone. We're open to anyone who wants to program something. You see CLEs to judges and attorneys. Of course, it's more than just CLEs, it's structured, like I said, but I'm just saying that as an example of the work that needs to be done.
I just want to follow up because you mentioned the Jay Johnson report 2020, and I've heard you, Your Honor, talk about that report, and you really do seem and are invested in the findings of that report and in implementing it, right? But personally, Matt, other people who appear in housing court, appear before judges, I don't know that I can say that I see the same level of investment in the findings of that report and in truly addressing racism in the courts that I see in you on other judges in the bench. And so obviously I'm not asking you to drop any names here, but I would really like to hear you talk more about the actual implementation when it comes to the judges, because a lot of what we hear when we talk about housing court, particularly from OCA, is that judges run their parts, and there's not that much really that OCA can do in terms of forcing judges to act in XYZ way. So would love it if you could expand a little bit more about, in reality, how is implementation of the recommendation of those reports kind of taking place?
Sure. The way the housing court administration is structured, there's a chief judge, there's a chief administrative judge who's sort of in charge of the nuts and bolts. And the chief administrative judge has two deputy judges, one who is running the courts inside New York City, one who's running courts outside New York City. A third deputy chief judge was, the position was created for both access to justice issues and for implementation of the Jay Johnson report, and that's Judge Edwina Richardson Mendelson. And so her office in 2020, after the Jay Johnson report, was vested with the power to implement it. So the court decided that this was something that was important enough to devote an entire deputy chief administrative judge to. And I have worked with Judge Richardson Mendelson on programming trainings that are, certainly the court system, as a part of the implementation report, has implemented trainings for judges, but I wanted to do it for things that were specific to housing court, because housing court has dynamics that are particular to housing court that you don't see in other courts, that you might not see in a town and village court in upstate New York or something. So the same trainings that they get might not be as effective or directed as the trainings that are specific to that. So I worked with the Office of Justice Initiatives to program trainings in our fall seminars specific to housing court. We've had those in our summer seminars. One thing that I do want to say though is that I think that if there's a problem with an individual judge, you said you didn't want to name names, and that's fine, but there's a certain management technique where, someone's creating a problem, but rather than single that person out, let's train everybody. My feeling is training everybody is good, but I think that tends to be less effective than getting notified about a particular person doing something wrong. So certainly, if housing court judges.
Advocates here in the invitation.
Probably only applause on it, yeah. Housing court judges have a very short term, you have a 5-year term, a reappointment every 5 years. Any feedback about a judge, positive or negative, goes in that judge's file and comes up with the review. I encourage anyone to send a letter to the supervising judge of the county if there's, if the judge is doing something inappropriate in any instance. And, you know, I mean, I see a lot of complaints. Some of the complaints have merit, some have don't, but the ones that have merit, the judges do get talked to. It does go into the file. It does become a thing that judges have to think about in terms of the appointment. And I think that, you know, I mean, it's a long road to go down. I mean, one other thing that I will note is that the Jay Johnson report also spoke about diversity in the bench. And I think housing court bench is not as diverse as it could be, but it's one of the most diverse benches in New York State. It's not perfect, we have a ways to go, but that is something that the new chief judge and chief administrative judge do take very seriously when they're looking at housing court judge applicants. And I would encourage, if there's anyone here in the room who's an attorney who feels strongly about this, put him to be a judge, seriously. We need good candidates, and I would encourage anyone who is an attorney and eligible to be a judge to apply, because we always need good judicial candidates.
Anyone else on the panel? Something in reaction to Judge Stoller or the topic of the demographics of tenants in housing court?
I'll say something about this. You know, I guess my view is, I think the things that Judge Stoll was talking about are great, and you need to deal with the behavior of individuals, but I really go back to the structure of the thing. You know, I don't think things are really going to change if you just try to, you know, keep people contained in that box that was created for reasons that had to do with power relations and oppressing people and keeping control, and then saying, yeah, but if we sort of make a few tweaks within it, things are really going to change. And housing court and summary fiction proceedings are the product of, you know, 200 years of history in which tenancy became racialized because opportunities for people of color to own homes were completely denied from public policy and private action. And they were created in the first place as an expedited remedy for white property owners to get rid of their tenants in an era when they were the only people who were able to vote. You had to be white, you had to own property to vote, and then they set up this system. And for whatever reasons, we've sustained it for 200 years, and then we put it in these little boxes we call housing court, and we say, you know, this is how we're going to address the problem of people needing a home to live in, and using people really as fodder for a system that needs to change pretty fundamentally. So, you know, yeah, we can sort of move the pieces inside the box and do better. But until we really rethink what we're doing about eviction and how we're going about it, I don't think things are really going to change. And, you know, I think we have to think big. I think we don't, you know, taking the kind of incremental steps, unless you really kind of bust it open and change it pretty fundamentally. I don't think. But you're the only one who's actually, you've read it.
Yeah, every time I have to think about creative legal defenses, I go to Shearer's book. He's a real expert in this field. I will say that.
One panelist telling another one, wait, you're the book.
So one thing that could bust this wide open is if we slow the pace of cases in housing court. And we have a resolution of the city council. When we talk about right to counsel, we mean right to counsel. And right now we have cases going through housing court where tenants facing eviction without a lawyer are being pushed through. To maintain housing security and preserve housing, I think one of the things that the courts can do, and I know that's something that can be done at the state level with OCA especially, we need to really slow down the pace of cases so that right to counsel, what it meant to us a few years ago, continues to mean that today. Right now, that's not happening.
So I think that's a good segue to talk a little bit more specifically about right to counsel and the implementation of right to counsel, which is a bit of the big topic that brings us together today, right? So back with you, Judge Stoller. So as the person who has the very small job of running the housing court citywide. What is your present view of housing court operations, in particular as it relates to like the council program? What's working, what's not working, whatever is not working, what and your team are doing to address it? And feel free, because you're at a level, there's people above you, so feel free to make reference in your answer to what is your purview versus perhaps things that you need from others that you may not be getting.
So my title's a bit of a misnomer. I'm a housing court judge, like all other housing court judges. If I were to tell a colleague to do something and they wouldn't do it, there's really nothing I could do to them. That's the people who are higher in the chain of command already. One of them, there's a lot less cases than there were before. That means that calendars now are at a smaller level than they have been. Smaller calendars is good for many reasons. One of the central administrative challenge of any judge is to give every case the attention it deserves, but also get through your day. And the bigger the calendar is, the harder it is to do that, the more you have implicit bias, that kind of thing. So the calendars now are more manageable than they have been in the past. I hear what you're saying about right to counsel. I just want to give a long view for a moment that I started as an attorney at Bronx Legal Services in 1994, and from then up to like 2017 or something, I don't know, 2% of tenants had attorneys. It was a tiny number. It's not as high as it should be now. I'd like it to be 100% of eligible tenants, but right now it's, I think, of total tenants, it's about 44% is the last number I saw. Not all those tenants are eligible under the statute you're talking about. We're not clear who that is because we in the court system don't ask tenants what their incomes are. But the fact that there are more tenants attorneys, not to say that we don't have a way to go, but it's an incredible improvement in a court system where you have a lot of tenants attorneys representing tenants as opposed to like 2% of tenants with attorneys. Smaller calendars better than big calendars. And the third improvement, which is probably less of concern to people in the room, is electronic filing, which I do think makes the court more accessible and makes things easier. So by those three metrics, the court system is better than it was a few years ago. The housing court is better than it was a few years ago. And I hope it continues along that path, and there's ways to talk about it. In terms of things that are worse, we've suffered from the same level of attrition that a lot of legal services providers have had in terms of our personnel. We've lost a lot of court attorneys. We've lost an incredible amount of interpreters. I know that I hear from all constituencies of housing court about how that really is a huge problem. I think before the pandemic, we had system-wide maybe 300 interpreters. Now we have like 240 or something. Percentage-wise, that's a huge drop, and that means that it makes court operations very difficult for court users for whom English is not their first language. It's not fair to them. And we've lost a huge amount of court attorneys and clerks, which really impairs the operation of day-to-day court. The other problem that is kind of flatlined is still the same problem as before, is the facilities. Our facilities are some of the worst in New York State. Those of you who have been to Brooklyn Housing Court in particular, I sometimes say landlords and tenants can unite against the common enemy, which is 141 Livingston Street. There have been plans afoot to move us, and it's like an ever-receding horizon as to when we're going to get relocated. In terms of
I was
that,
hearing about that move, like, what, in 2015?
there was supposed to be a move to a building on Geralman Street, and they found asbestos, and they had to bid it out, and then the pandemic, and that pushed everything back. I think 2025 is when they're talking about now. So in terms of facilities, we definitely, and this ties into your previous question, why is our court, with the clientele we have, why do we have the worst facilities? Why do we have these private calendars? Why do we have all these disadvantages? And so it is about advocating for my court within the system that we're talking about. As you know, we got a new chief judge earlier this year and a new chief administrative judge. And I feel like the attention that they have lavished on the court is something I'm not used to. They strike me as being very invested in the court. They seem to be very receptive to things that have to get changed. The problem is a lot of things are hard to change. You want to get more interpreters, more judges. Well, you have to hire more people. You have to have the test for interpreters. We didn't have a test for independent. There's all these logistical challenges that we're bumping up against. So I think we're all aware of progress we've made, what's happened, what we have to do to fix things and go forward. And So that's a very, sorry, long and rambling answer to your questions.
Very quickly, Judge, it is my understanding of state law that once the case is filed, the case has to be calendared within a certain amount of time. But once the case is underway, my view of this is that some judges are more amenable to grant adjournments so that tenants can be matched with the right to counsel attorney, while others are less amenable. Is there anything that the court system can do to create some internal standards so that more judges comprehensively are granting those adjournments when those adjournments are going to lead to a tenant that qualifies for the right to counsel program getting matched with that attorney?
So there are things that we have done already. It used to be, and again, I'm going to date myself, I've been practicing in housing court since 1994. It used to be the case first time on, the case would step out, usually with a final judgment. That was very common. With the introduction of what they call the zip code parts, they started to change that so that cases would get adjourned before there would be a disposition on the case, the tenants get referred to counsel. And then during the pandemic, that became citywide. Now, first time on, there are intake parts where the idea is that cases will get adjourned first time on. And in Kings County in particular, I'm sure many of you know, there's a pilot program where in addition to getting referred to counsel, we're referring tenants to HRA for those cases that could be resolved with rent arrears getting paid, hoping to dispose of as many of those cases as possible so as to maximize the number of tenants who could be eligible for counsel. So there are things that tenants have done in the meantime. I'm sorry, that the court system's done in the meantime to try and incorporate a vision of the court where maximization of tenants with attorneys occurs. After that, yes, judges do have discretion. Some judges exercise their discretion in different ways than others. Certainly the kinds of things that Councilmember Abreu has talked about, having cases be stayed, those requests have been made to the people whose pay grade is above mine who make these decisions. They've entertained requests for that from the Right to Counsel Coalition, from various elected officials. It is the feeling of Office of Court Administration that that's not something that an administrative judge can tell a trial level judge what to do. It's kind of similar to, within certain limitations, you can say, yeah, we're going to have some procedures in place to get
You can use your powers of persuasion.
I'm sorry?
You can use your powers of persuasion as the supervising.
Sure, I don't have to use my powers of persuasion for the most part. My colleagues, I gotta tell you, we so much prefer to have tenants represented by attorneys, and that's not, I'm not just saying that as, to be, to suck up to the crowd or anything. And obviously it's an access to justice issue, but from our personal selfish interest, it's so much easier to have an attorney in front of us than have a pro se party. When you have a pro se party in front of you, you have to navigate between trying to make sure that there's not overreach, trying to make sure that the pro se party understands everything, but you also can't be the pro se party's attorney. To navigate that, it can be done, but it's exhausting. It's much better to have an attorney in front of us. And we're deeply frustrated when tenants are unable to get attorneys, and we're also frustrated when we see motions from attorneys to be relieved as counsel for tenants, which we see sometimes. So, I think that to the extent that you might see variances in terms of adjournments, I will say that about 6 out of every 7 cases does get adjourned now on a daily basis. So it's much more common for cases to get adjourned than for dispositions. Different judges have different level of tolerance for how many adjournments there are, but at a certain point, where the new law says that we have to be very careful to make sure that tenants are not signing stipulations that they don't want to sign. Cases can get referred for trial, and when they get referred for trial, they get adjourned some more. Again, if you think that there's an individual judge who's doing something improper, you can write a letter to a supervising judge, but if you're talking about just varying levels of tolerance for adjournments, that, is a thing that is individualized for judges.
Any comments or responses?
I will just add that there's still things that I think the court can do to make it better for litigants. I'm sorry. There's still things that the court can do to make it better for litigants, especially while they have to possibly be pro se and not have an attorney through this process. I think judges are trained better, it has become a more diverse bench, I will agree with that. The pace of housing court has probably changed. When I started practicing, you could get a case on a Tuesday, you could be in court on Thursday, and you could be in trial Thursday afternoon. Like, that pace is no longer present in the same way. But the volume of cases and seeing landlords attorneys who have duplicate cases and the court not even having the time, probably, judges not even having the time to look to see, oh wait, there's 2 other cases, and then the tenants getting confused because they don't know which case they can go on. I mean, that's just an example of a situation where I think the court can easily do better by looking in the court database system to see what's going on. I know that there's been problems with staffing at every level of the court and also legal service providers among others, but in the Bronx, where I predominantly practice, we're still not seeing stipulations and things uploaded to NICEF for months. And those are the types of things that, we've gone back to a system in some ways where it's pre-pandemic, we're still using carbon copy forms, we're not giving, maybe this is also a bias that Your Honor has pointed out in the court, that the court itself is not given the technology it probably needs so that people can have access to things when they need it, such as being able to file things online, being able to print stuff, being able to upload things in a timely manner. But I mean, there are things that the court systems can still do even with the limited resources that they can do better.
All right, let's switch a little bit to the one organization, Ms. Springer. The Right to Counsel Coalition campaigned to get Right to Counsel approved at the city level, and is now campaigning for a statewide Right to Counsel, as well as other campaigns, including the Housing Court Must Change campaign. Can you describe the coalition's current campaigns and overall vision and goals?
Sure. I just want to reiterate that the 2017 law, Right to Counsel law, was passed really as a result of the tenant-led campaign, 3-year fight. Even though people have been fighting for this for decades, it was tenants that won this. And it's disheartening to see, let me say this, after it was passed, it was effective, as already is pointed out by members of this panel. Eviction filings were down, more than 80, somewhere between 84 to 86% of tenants were able to stay in their homes. There was less default judgments because tenants were showing up for their cases and everything else. And where it got subverted is really after the eviction moratorium lifted. And you have this flood of cases coming into court, so whether it was backlog cases or new eviction filings. And then, as Jeff Solar was saying, the courts are affected by the national labor shortage, so are legal services providers. And so as far as our campaign is, we've been fighting to basically defend RTC and also pass statewide RTC. And in terms of defending our citywide RTC, what we've been doing is we've been pushing for an administrative order to be issued that would slow down the cases, that would grant adjournments until eligible tenants are able to get secure counsel. It would also match the daily calendar caseload to lawyer capacity. And then would also, what we wanted was for there to be no new case filings until the backlogs were taken care of. And then we also wanted sufficient time in between cases, between court appearances, so that attorneys had time to basically prepare for their cases. You have a right, you have a right to an attorney, and we don't call it access, the coalition does not call it access to counsel or access to universal whatever. We call it a right to counsel, and there's a reason why we call it a right to counsel. And that's so that tenants will effectuate that right. They'll cling to that right, and they'll actually do something about it. So that was one aspect. What we've also done is we've been trying to get, we have a standalone bill in the state legislature that would protect the right to counsel in terms of making sure that adjournments, that tenants get their adjournment. So we'll basically protect the right to counsel law in the city and then also in Westchester County. And with respect to trying to get that administrative order, we've met with electeds. We did also meet twice with Judge Rowan Wilson to try and get that administrative order. And one thing I want to say with respect to having an administrative order is that it is our position that the judge has the authority to do that. And I want to point out, during the COVID crisis, all sorts of administrative orders were coming out from the court, the stating statutes of limitations that were doing, getting adjournments, that basically even state these eviction proceedings. So there is precedent for this. And I also think in terms of what you pointed out about the fact that some judges are more willing to grant adjournments than others, that just perpetuates the fact that you're getting what happens in your case depends on what judge you're before, continues to perpetuate these inequities. Why should it depend on that? So we've also been fighting for state passage of statewide right to counsel that would strengthen the city's law, but it would also guarantee a right to counsel for everybody across the state. And then it would actually basically broaden the types of cases that would get coverage for. So it wouldn't just have to be eviction proceedings. It's any case in which anybody's risking the loss of housing. So it's beyond non-payment issues. And then also it would give the right to people who aren't covered right now, like people in public housing and everything like that. So we've been meeting with electeds to do this. We've been taking electeds and housing court tours. And I want to point out, so it was interesting, one of the housing court tours that I was on in Manhattan Housing Court is that literally one of the, it was somebody from one of the electeds' office was literally able to stop a landlord's attorney from trying to pull the wool over the eyes of a tenant. They were talking to them in the hall. The tenant thought that this person was their lawyer and had their best interests at heart, and they put a stop to that. What else did I say? So yeah, so we've also been fighting. We have another piece of legislation, winter eviction moratorium, where it would prevent evictions from taking place or being carried out, warrants from being executed between, I think it's, what is it, May, and then it's May 31st, it's like October 1st to May 31st in any calendar year. So we've been fighting on different fronts. We've been doing court outreach, so we actually go into the courts and meet up with tenants so that they know about their rights, because that's also been an issue. Even when right to counsel was initially passed, a lot of tenants didn't know that they had this right. And if you don't know that you have a right, you're not gonna exercise it. So that's one of the things. We've also been doing court watch, so we go into the courts and see and document the kinds of things that are going on there. So it's just a multifaceted front. And as far as what our I guess our immediate vision is to basically uphold tenants' rights, hold landlords accountable, make sure our tenants' rights are protected. But far-reaching is really for an eviction-free city and an eviction-free state.
I'm gonna ask you, what did housing justice look like in the long term for you? I think you just answered that right there. So you're working every day as an organizer to grow the tenant movement, right? To bring more people to the tenant movement. In addition to the work of organizations like yourself, how do you envision all of us in this room, we have lawyers, policymakers, students, organizers, etc. How should everyone together be working to grow the tenant movement?
Okay, just to clarify, I'm not an organizer. I am a tenant leader, so I work with organizers. And also to clarify, one of the things, it's in the bio, I believe, I'm a criminal defense attorney. So a lot of the way I look at this is also not just from the viewpoint as a tenant, I'm a long-time tenant, as a tenant leader, but also as an attorney, and seeing the difference that people, basically the difference in treatment and the difference in outcome when someone is represented in court, and whether that's, you're talking about housing court, or whether you're talking about criminal court. As far as a broader vision, I think we all need to be involved in the fight I think, we need to be working together in order to change the system. And Andy's right, it's a systemic change that's required. My feeling on a lot of things lately is that whatever rights you win, you have to keep on fighting for, because it's basically the forces of the status quo are strong and try to take you right back to where you started from. And you see that in other movements, whether it's the civil rights movement or anything else like that. So it really is us being aware of what our rights are, letting people know what our rights are, and combining forces to be able to fight and make sure that change actually happens, that we're protecting the rights of the marginalized, that we're protecting or actually prioritizing rights of people and people in general over property and profits.
So let's move on to talk a little bit about some dollars and cents in terms of the Right to Counsel program. We'd love to hear from council member, from Matt as a practitioner, Judge Stoller, and anyone else, right? So the Universal Access Caseload Working Group issued a report where they recommended a maximum of 48 cases per year for a right to counsel attorney, right? Furthermore, legal services providers have said that each case costs $7,500 to litigate, right? Each housing court case. And that a fully funded right to counsel program for this year would be estimated at $461 million. And so what can you all tell us about those numbers in terms of, are we there, we are not there? What steps are we taking to get to a fully funded program? And where does that buck stop? Like who's got the purse position?
I can speak to that. So this past year, the city council, through my leadership and Irina Sanchez's leadership, among other colleagues, we led the fight for right to counsel funding, fair funding, dating months before the budget was adopted. We were able to secure $20 million baseline, which in the grand scheme of things is a drop in the bucket. It was a tough budget year, and a lot of social services were cut. So $20 million was definitely committed for it, but it falls very well short of the $461 million we need. When we think about right to counsel funding, it's important to think about everything that goes into it. You need better pay for attorneys who are leaving the public sector to the private sector because they're being paid too low. They're also being overburdened. We're talking about cases. In a given year, 40 cases was about the sweet spot for me. We know that we have public defenders even taking 100 cases at any given moment. When you think about the fact that, when you think about the criminal side, you have prosecutors that have attorneys publicly funded, but on the public defender side, it's not enough. We're seeing the same thing in housing court as well. But the case cap is very, very important, and we don't have that being reflected right now in RFXs, the request for proposals being sent by providers. And we need that. Without a case cap, you're gonna continue to see the attrition go through the roof. People are gonna be tired and they're gonna be leaving. And what does that mean? We're now gonna have a system where we're gonna have poor quality representation, because now you have to focus on 100 cases as opposed to 40 or so. And you can't give your attention and your every fiber of your being to these cases when you're being subjected to this. So we need to look at cases. We also need to look at also case caps and case overload. But on the other side, we have to take into account that the impact that courts have in this process as well. Because the court systems also contribute to attrition too, when the related cases go through in housing court, where tenants are entitled to a lawyer and they're not getting one. What's also a dire situation is that now, under these proposals, the mayor is requesting that there be $3,000 per case. Meanwhile, we know that a case costs about $7,500. So now the administration is creating an impossible situation for providers to be able to provide this quality service under these case rates. These case rates are really unimaginable and they're not realistic. So that's part of the problem. So we need 461 million. Do we need it all in 1 year? I would say yes. Is it realistic? Probably not. But it just sucks that it's not realistically what's needed. But we need a real gain this next year. And building off the 20 million that we got this past year, that's baseline, we need to fight for it again next year. We need a lot of resources coming. And I just want you to know that sometimes it can seem that, government is not paying attention. I want you to know that we are. It's just that right now we're faced, I believe, with an administration that is designed to cripple tenant rights. And it's our job in the city council, we're doing it, to bring the funding that's necessary for right to counsel. I made it my life's fight, and I'm gonna continue to join you in that fight. So I wanna say thank you for bringing all the voices at the table, because we're up against some serious monsters. Thank you.
I take it you would come up with a 461 yourself if you could. So my question to you is, the council, above and beyond yourself, the council as a body, is it your belief that the council is doing everything that it can do to throw as much money as possible to funding the right to counsel program?
I can tell you that's, when we're at the table, right, Speaker Adams has made it her priority to make sure that we have funding for right to counsel. But, I have, my only interest in negotiations is usually right to counsel come budget season. But you have people fighting for cultural institutions, very important, right? So there's only so much piece of the pie. I try to make it as big as we can for right to counsel every single time. It's only been my second budget, but we will continue to do that. I think there's always a lot more we can do, to your question. I think that we have a lot of people who are interested in it, but it doesn't hurt to get another few more members behind, support it, and making it their priority.
Can I just add to that? It's interesting. I also think that education efforts are important too in this, because one of the things that we've encountered sometimes is when people talk about right to counsel in housing court, people are like, well, what did that already exist? Because they're assuming that because there's a right to counsel in criminal court, there was always one in housing court. So I think, education is also important to all of this.
On the topic of resources, overburdened caseloads, all that good stuff, Matt, do you have anything to add in terms of the perspective of attorneys and practitioners in housing court?
Probably have a lot to add, and I don't want to bore the whole room, as this probably consumes way more of my time and energy than I would probably prefer to, and I'd rather be focusing on doing the litigation and making sure our staff is supported in that way. But I agree with everything that Councilmember said. We need more funding, that is true. But the implementation problems aren't just funding from our perspective. That is a big component of it. Because even if you fund it at the level that is being proposed, it still wouldn't match the volume of the cases that currently exist. So it wouldn't match that. So they're trying to say that, we as legal service providers sometimes do not have enough staff to be able to handle the volume and we have capacity issues. That's true, but it's not the whole picture. The other part of this is it takes a while to build up the pipeline of attorneys that need to do this type of work. I teach a clinic at Columbia, and as part of that, we try to explain to people what it's like to be a public interest lawyer. It's part of, I think, educating law students to go into this type of work. I know Professor Scherer does a lot of that with my alma mater, New York Law School. It's important. We need more in larger pool that's diverse, that looks like a lot of the clients that we represent. I think that is very important. And right now, even if we had, even if you said, here's all the money, there is not enough attorneys out there to hire to do that work. It just doesn't exist yet. So there's more years that probably, I'm talking years, that need to go into this to create that type of pipeline to do this work. Also, it gets to, this work is hard, right? We deal with people who are going through crisis. And that is hard on attorneys. But obviously, it's not nearly as hard as people who are going through those traumas, but that is also something that is difficult. So retaining staff, being mindful of their caseloads and making sure that they're supported in a way that they can stay in doing this work for more than just a few years is something that we are constantly trying to do. And I think, Warren, you mentioned that it's disheartening for tenants and advocates to see cases going forward without attorneys. I can agree, it's demoralizing for us as legal service providers as well, to see a case where we know we can do something for them, and we can almost always do something. To see them go forward and not be able to help the extremely vulnerable population that's going through housing court is very hard. So you have to not only have a large pool, as I said before, but you also need to create the right type of mindsets to be in this fight. This is a fight. We're as legal service providers, we're at I think, a fight for right to counsel right now, and it's at a important, I would say, crisis point where, you know, these contracts are going to be renewed, and we're fighting for what that looks like, and we're also always advocating to make sure that the program works in a way that benefits our tenant community, and right now it's not. I think everyone can agree it's not working the way it's supposed to. But it's not just a funding solution, unfortunately. And I wish it were. That would be nice to just focus on one thing. It's more complicated than that.
Can I say, piggyback on that? I 100% agree. The pipeline is something that is critical. If we have, you know, more legal clinics that have right to counsel days, for instance, in all of our law schools in New York City, I mean, that would be great. I think we need to develop that pipeline, but also know that when we ask for more case caps, that's going to mean we other lawyers take up the other cases. So that's why the pipeline is going to be very critical.
Sorry. I also wanted to add, I agree with both gentlemen's comments. But one of the things I wanted to add, part of that in terms of, and the pipeline will take time, but part of building that pipeline has to include making sure that there are livable that people are making livable salaries, and then there's also some sort of loan repayment assistance or some sort of funding to make it, you know, to help people with their law school debts.
Yes. We've been talking about the law school practitioner pipeline. You're involved in that, Professor. Can you talk a little bit about that?
Yeah, actually, I want to make a comment about the discussion that we've been having so far about, I totally agree with the goals of the Right to Counsel Coalition and what we're really aiming for is an eviction-free New York City. And I think in that light, we have to take the right to counsel as part of a bigger project, which, I don't think it's simply about taking kind of the existing state things in housing court and then staffing up with attorneys so that everybody will have a lawyer, but the existing state of things just stays the same. So I think we have to be thinking, we as a community, of this as really part of a bigger project. And that's why it's so important that the right to counsel funding be adequate, because I think the role of attorneys in the sense of it being a bigger project is somewhat different than just the representation of people in housing. Right? And I think, attorneys who are doing right to counsel work should be engaged with the communities that they are working in and working for change and supporting advocacy at the community level and at the broader level, which takes time, but I think in the long run it's going to, really, really change the dynamic. And we have to think of, again, we can't accept status quo. I think we have to think of housing court as something that's time has passed. And it's not even, whether we call it housing court or we don't, but we need to sort of, part of the project is to move on so that we don't just so cavalierly treat eviction as something that, is supposed to happen immediately. And so we need to look for upstream solutions so cases never get into court in the first place. Like why does somebody have to be facing eviction for HRA to do its job, right? We have to think of ways to keep the cases out of the court in the first place. and think of the role of advocacy much more broadly than simply, not that it's not important, but that what's going on in the court. And the role of attorney also should be, shaping issues for appeal that need to be appealed and getting the law interpreted in ways that would, advance the interests of tenants. So that's all part of it. The pipeline piece is crucial, and I have been, in various ways working for years to sort of try to change the climate around that. But we have to convince law students that, you see them every day, that working as a housing rights attorney is a really cool, fun thing to do. And frankly, I think done right it is. I mean, if you can be engaged with community struggles, if you can be part of a broader movement that's really trying to make change in the world, that's exciting. So I think we also just have to sort of cast it in the right light. And then, I keep saying this, but we also have to get like a TV show with lots of sex and violence about what it's like to be a housing rights attorney, because that's how we're really going to do it. We need that's it.
Right, so you're saying you need a show about housing attorneys like me?
Yeah, yeah, you can get started.
On a TV show, you can try it. Perfect segue, Professor, to talk about the broader picture, not just right to counsel. We're here to focus on right to counsel and its implementation, but I really want to get to Community Service Society, because you all have done some very interesting reports as of late, particularly one concerning social housing. So, Oksana, CSS published a report called Pathways to Social Housing in New York, 20 policies to shift from private profit to public good. And you and your team gave a presentation to Housing Board Answers about that report. Can you talk about how social housing could change the current state of housing insecurity and homelessness in New York City, as well as steps the city could be taking right now to move in that direction?
Yeah, thank you. That was a very masterful segue. So we have been working on the issue of social housing for a couple of years now. And social housing is a concept that is well known in other parts of the world, particularly in a couple of Latin American countries, a couple of countries in Asia and in Europe. But it's not something that we really talk about that much in the US. Part of there's the kind of like, the historical reasons for that are vast, and I can talk to you about them offline. When we talk about social housing at CSS, we like to think of it as an umbrella term for everything that is all the housing in New York City and also other cities in the US that are removed from the speculative housing market in some way, that have some matter of residents of the housing making bigger decisions about what happens in the building or in whatever the structure is, so some level of tenant control, and some level of social equality as well, so housing that is moving towards desegregation by race and by income. In application, that looks like public housing, that looks like Michelama co-ops, that looks like HDFC co-ops, and community land trusts too. And there's a bunch of, there's a bunch of exciting things happening on all fronts. They're all pretty under attack. All of those housing models are under attack because we live in an austerity regime where all levels of government are just either actively trying to destroy those housing models or are just kind of like neglecting them, basically. But it absolutely doesn't have to be that way. And there are lots of things that can happen now in order to expand all of those housing stocks. One of them is the federal government actually funding public housing. That seems far away, but that is one step. The other step is material and political resources for the expansion of things like community land trusts, the state investing in a program that is similar to what Michelama is. And then taking kind of a step back and thinking about all of these housing models in the context of the housing system that we have now, everything that strengthens tenants' rights, whether it's right to counsel, whether it's good cause, whether it's expanding the HSPPA to include more forms of housing. So right now the HSPPA is pretty limited to like buildings that were built before 1974 that have more than 6 units, and are just New York City and a couple of other suburban counties in the state. So expanding that definition out. All of that is helpful for kind of like more decommodified housing stocks because it makes it, if you have a tighter regulatory framework, then community land trusts, people who want to develop community land trusts, even the government has more ability to compete for land parcels. That is impossible to do in New York City right now because the property values are just overblown. So if you have more regulation, if you have tenants' rights, more tenants actually being able to assert their rights, whether it's in the court system or more generally, it makes it more possible for people to actually take over their housing and run it on their own, and to diminish the profit motive that Lauren was talking about earlier.
From the perspective of the Right to Counsel Coalition and from the perspective of the council, anything to add in terms of not Right to Counsel specifically, but other programs, other themes we need to be pushing towards the broader goal of housing stability?
I can speak to that partly. I think that it's important for us to build housing everywhere in New York City and build truly affordable housing. I think that there's a lot of NIMBYism that's really at the core of a lot of lack of housing production in New York. I think it's important to also be focused on supportive housing as well for people in need and who need the comprehensive services at where they live. So I think this is all part of the larger picture. When someone tells you that they want 100% affordable housing on non-city land, sometimes that's masked in NIMBYism. It's almost hard to happen as there's so market rate units. I think it's important to understand that as well. The way that financing works of housing is very important for everybody to understand, because I'm worried that these talking points are having the actually opposite impact of exclusionary housing policies.
Professor, you mentioned this a little bit, but I want to mention your article specifically, give you an opportunity to talk about anything you may not have touched upon. So you wrote an article recently called "The Case Against Summary Proceedings, Process as Racism and Oppression," where you say in the first line, literally your first line of your article, you say, quote, "The right to counsel in evictions helps level the playing field, but it's time to revise the rules of the game." Tell us more about that.
Yeah. So, our success thus far with the right to counsel, sort of combined with seeing the courts just shut down completely the pandemic, I think got me to thinking about something that's kind of like bounced around for all my years. And why do we have summary proceedings? This is one of the most important things that the courts deal with. It's, somebody's ability to stay in their home and in their community with the long-term consequences of not being able to stay in your home, the trauma of eviction, the consequences for the kid's education, for your ability to hold a job, for all kinds of things, your ability to be a political being and have a place in which you vote and be part of the political process. So I did a bit of a deep dive. I'll try to give you the 2-minute version of an 80-page paper, which is that, as I said before, summary proceedings were created in pretty much every state in this country, or as they became states, to deal with eviction matters, and they're an exception to the regular civil process, and they were passed into law at a time when only property-owning white men were able to vote or hold political office. And they essentially said, well, if we want to get rid of somebody We need a fast process that's, exempts us from the regular strictures of civil litigation. And so they were unfair to begin with. They reflected a power relationship between, we still use the word landlord and tenant, very feudal, straight out of feudalism. The word evict itself comes from the Latin for to conquer, right? So, the premise of the whole thing and the language that we use is really all about power, and we've kept them in place. And in those 200 years, New York's law was 1820, landlord-tenant relations have become racialized. After emancipation, we had Jim Crow laws for the better part of a century. Even when the public housing got started in the 30s, the Roosevelt administration mandated racial segregation in public housing. When the mortgage industry developed initially, the Fed said that they would insure banks only if the properties were in racially segregated neighborhoods. We had urban renewal that James Baldwin called Negro removal, pushing low-income people of color out of communities. We have redlining that continues to this day. So the avenues for people of color, and black people in particular, to get access to property ownership have been denied over the years. So you get something that was unfair to begin with, and in the course of, I think actually the tenants were white tenants that the white property owners were trying to get, have the tools to get rid of 200 years ago. But tenancy has become in many ways racialized. You have something that was historically unfair, and then it has become unfair on a structural racist line. And so that's why I say it's, and it's the process itself, right? It's we can talk about the process that frankly has led to the facilities problems, to the idea that the judges are kind of second-class judges, that the funding for housing court, there's 50 housing court judges in New York City. The federal court, district court judges, and the magistrates handle about the same number of cases as New York City's housing court, yet they have about 1,300 judges for that number of cases in the federal courts. They spend, more than $85 times as much per case as the New York City Housing Court does. So we've made these decisions, we've prioritized, and I think we've in many ways kept it the way it is because of the racial, demographics of it. And I think we need to rethink it. And when better time than now? 50th anniversary of the housing court. We just came through a pandemic where for the first time in the history of the United States, we went through a period of time when almost nobody got evicted. Hey, we could do that. We can do it. And I think we need to look for ways to do it. And where I would really start is teasing out what's the problem here, right? And I think in part it's the problem that we have a statute that gives far fewer rights in these type of proceedings than people have in other proceedings, even though we have a constitutional right to due process, which you would think would mean that the more valuable the property is that's being taken away, the more due process you should have, and what could be more valuable than somebody's ability to stay in their home. So anyway, that's my argument in a nutshell.
Very quick follow-up question, and then I want to get to questions from the audience because now I have quite a few. Are you aware of any actual political or lawmaking efforts moving in the direction that you are actually eliminating solar proceedings and making Asian cases plenary?
I'm not, but I hope that will take shape. I don't harbor the illusion that we could do this overnight. It is 200 years in place, But what I'm doing at this point is I just want people to think about this. I want people to put it together, you know, and where it goes from there, I don't know, you know. I mean, you know, will I see in my lifetime that change? I hope so. But, you know, I think people need to really be thinking about it. And maybe I'm jumping the gun. I know you were going to ask me about, so what happens if we get rid of summary proceedings? And, you know, we do have, you know, statutory provisions that would allow for litigation that's much more comparable to other kinds of civil litigation that could be used right off the bat if you just, you know, simply repeal the summary proceedings statute. But actually, I think, you know, I mean, you know, here I am like an old white guy, you know, making this analysis, and I don't think it's my place, frankly, to come up with what replaces it. I think that the community needs to be involved, and people need to think about, you know, yes, we need to get rid of this thing, but, you know, what's it going to look like if we get rid of it? And that's, you know, that's a process. And I think, you know, there should be that process, and we should develop a vision for a world where people just don't get evicted. And then when these conflicts come up, how do we as a society resolve those conflicts? And, you know, that's kind of the next step. And yeah, I don't have the answer to that step.
Anyone else on the panel have any final thoughts about these types of cases actually being heard in something other than what the housing court is nowadays?
I mean, it's definitely something interesting to think about. You know, I hope that happens someday. I hope I am put out of a job, basically, right now. That would be a fun role. I did want to know, like, there is a role for tenants attorneys, even without a right to counsel. You know, it's spending more resources to be able to fight for habitable housing, more affordable housing, helping to advocate within communities to educate and empower them. Like, there are roles. What that looks like, I do agree with Professor Scherer, where there are statutes in place that could easily be used to create more of a system. I just hope it wouldn't become something more of what we see in like ejectment actions in Supreme Courts. And in those cases, I think people often also don't have representation. But if you make it harder to file cases, the filing fees probably should be raised. How long cases go, like, it will disincentivize over time those cases. So if we can come up with a new system, I think I would be all for it. But it is definitely something interesting to think about. Hopefully, you know, as we come together in these types of events, and thank you again to Housing Court Answers for putting on such a great event every year. These are the types of things that I hope we start to discuss even more, because I don't want to spend all the time talking about how we find right to counsel. I hope basically that we eventually get to a place where we don't necessarily need it.
So let's start talking about a few questions from the audience. There's a lot, thank you. I don't think we'll get to all of them, but I'm going to try my best to group them. I'm already seeing the first few questions actually all in some way or shape relate to rental assistance funding. Right? So folks are essentially saying, vulnerable communities are still feeling the impacts of the COVID-19 pandemic. Now the housing court is ramping up, albeit not at the level that it was before, but it is ramping up. And there are various examples that I see in these questions about folks that are not really accessing rental assistance. So a question for the panel, for those of you who know, in terms of the money that is devoted for rental assistance, what is the state of that? Are there efforts to expand the pool of rental assistance so that it reaches more tenants who are facing eviction?
I can start there. So at the beginning of this conference, city council members, I think it's not now, but Pierre Sanchez talked about city bucks. And the city council did a huge thing. And there's been an explosion of other stuff that has been happening around housing in the city, specifically with right to shelter. So kind of got pushed down a little bit, but the city council, through a mayoral veto, pushed through a huge expansion of the city's rental assistance program, which is called City Cups. And it's set to go into effect, and I feel like we're all kind of waiting to see what the mayor is going to do, whether or not the mayoral administration is going to sue. We're still in an austerity regime. City FEPS, as it stands now, is extremely underfunded. But if the law actually goes into effect, it would change the way that the system works, where right now, in order to get a voucher, a city FEPS voucher, you have to go through this very convoluted process, go into the shelter system, and then work with someone in the shelter system to be able to get a voucher, and then it's like convoluted and impossible. This would make the vouchers available to people who are facing eviction, which is a huge change, and it would be expanded to way more people. So we have the legal framework for a city that actually helps people before they get evicted, before they get into the shelter. The resources, on the other hand, are a question, and I think that maybe the council member could talk about that more. Then, on the state level, we're also fighting for the housing access voucher program too, which would be, again, another big game changer. It almost came to be last year, it almost came to be 2 years ago. We have a governor that's really resistant to any kind of measures that expand funding to lower people. So there's kind of like a political problem there. But housing access vouchers would basically be a state version of Section 8. Other states have this, it's great, but we don't.
We're in a law school here, so interesting question. Students have been historically left out of affordable housing options in the city as their financial aid from school is seen as income. Is there any room in current advocacy for diversifying housing options for students? We're gonna leave that as a great question. How can NYCHA tenants ensure that they are appointed an attorney to represent them in termination cases rather than being told that there are no attorneys available? This is the topic that we didn't touch upon specifically. I think my understanding is that the city funding to fund the right to counsel program went first to tenants living in private housing, and public housing tenants were certainly put in the back. Can any of you talk about the state of right to counsel funding for NYCHA tenants, specifically in termination proceedings, which are not yet cases that are in court?
Yeah, I don't know if that's exactly true, because there is a right to counsel program for people going through determination hearings at the New York City Housing Authority. But like the ones that are going through regular housing court, there's the same problem. There's capacity issues with legal service providers, there's probably still too many cases. But many legal service providers who do the right to counsel work in regular housing court also are doing it in the NYCHA administrative forums. But it's just the same tensions we've talked about the whole time. So it's not just that NYCHA tenants are feeling that, adult tenants that are feeling that, NYCHA tenants as well. But there is a process where they are at least supposed to be linked to a legal service provider in the same way that is done in housing court. There is a gap though in some of those where it's not a termination of tenancy proceeding, but maybe someone's going to be terminated from their subsidy, and there's a gap in the law there. You know, they would have to probably incorporate the law to include those types of proceedings to be covered under that.
I see questions, a lot of them topics that we have spoken about, more evictions cases than repair cases in housing court. A question that presents a little bit of a different perspective, and I think there's story, you touched about this a little bit. Someone wrote, eviction fines in New York City are about half as high as they were pre-pandemic, while other cities have seen huge surges to historic levels. What explains the lower case levels here in New York City, and why is that not being talked about as a success?
I think it is a success. That's an interesting use of the passive voice. Why isn't that talk? I talk about it as a success. I mean, I think that I think the difference in New York City is tenant lawyers and the HSTPA, and I think the HSTPA has more of an impact on New York City than outside of New York City in that regard. Because what the HSTPA did was took away the incentives for landlords to regain possession of rent-stabilized apartments, and there's some rent stabilization outside New York City, elsewhere in New York State, but really it's New York City. So I think that that's, you know, I'm not a statistician, I don't know, but if I had to guess, that would be two things that are very distinct to New York City as opposed to other parts of the country.
You know, I think if you look at it over the long haul, granted, there are lots of issues that still need to be worked out. Certainly not, right to council is not by any means where it needs to be right now. But, you know, not that many years ago, there were 300,000 cases being filed in housing. 1% of the tenants have counsel, right? And, you know, filings have gone down, evictions have gone down, entries into the shelter system due to eviction have gone down. And this community, you know, looking at it all, has done an incredible job of making change. It ain't over, you know, and we're in the middle of a process. But I mean, I think if you take the long view, things are so remarkably better than they used to be. I know that may not, you know, be much consolation, and there are difficulties and obstacles and roadblocks, but things are really a lot better than they used to be because of the work of the advocacy community. So I think we should acknowledge that, and, you know, take some pride in that.
We don't need to be entirely depressed.
No, we can still be depressed, that's fine. But yeah, I think that is HSTPA and right to counsel is exactly right. And I would also say that I think that other states and other cities are absolutely paying attention. There's been a hugely renewed interest in fighting for rent control and rent stabilization across the country, which is, it's shocking because if you even look back to like 2015, 2016, the idea of rent stabilization in like Florida seemed absolutely insane. And it still is. It still, but there's local organizers fighting for rent stabilization in Orlando. There's people fighting to lift rent control bans in Nevada and Colorado, so like western and southern states. And people are absolutely looking to New York and paying attention to what we're doing. So yeah, like I think setting New York kind of like continuing to set housing policy is something that we often don't think about, but we should be thinking about. And building those relationships with housing organizers and tenant lawyers perhaps in other countries is really important.
And New York City's been an inspiration for the rest of the country around right to counsel. There's now 18 localities and 3 states that have adopted some version of right to counsel, you know, since we first adopted it in 2017. So, you know, we've really inspired and led the country on this.
Question here, bringing in nuance that we haven't discussed this morning. So much of tenant organizing and legal advocacy depends on agencies such as HRA and HPD adequately performing their functions. With short staffing and ineffectiveness of these agencies, how can we as tenant advocates work with and around these agencies that are almost entirely off limits to public influence?
I can speak to HPD and city agencies. In many ways, city agencies have contributed to the eviction crisis in New York. And it's crazy to think that, maybe not always, but to think that government is a contributor to our housing crisis. For instance, earlier this year, I passed a bill that would allow for electronic payment options from tenants to their landlords for HRA voucher holders. There are a lot, I can't tell you how many times I was in housing court where HRA did not make its payment on time to the landlord. Think about that. We're in housing court because government is not doing its job. And so historically, government would have to send a check to the landlord. And every time I was in housing court, government said the check was in the mail, landlord was like, I don't have the check, so there was no way to resolve that. What about an electronic payment option? Everybody agrees it's the right thing to do, and those negotiations were roughly at the council level. But at the core of this too is a staffing crisis. We don't have enough HRA employees to process payments. We don't have enough HPD employees to create affordable housing. And so navigating this is really keeping pressure on the administration to make sure that we're doing more hiring halls, to making sure that we're focusing on essential services that government provides that we often take for granted. And that's going to require an infusion of resources as with everything else, and being intent about it.
I wanted to say two things real quick and answer the question. First, in, I believe it was 2019, the state legislature amended New York City Civil Court Act to give housing court judges the power to join HRA and Adult Protective Services to a housing court case. Now, it's a little bit unclear as to what that means. I don't know if that means I have mandamus authority to order something. But it's something that one of my colleagues has published a decision on. It's a case where HRA was just not doing what they were supposed to do, and Judge Karen McTyan wrote an order joining them to the case. My experience has been that when something like that happens, it effectuates a solution to the problem really quickly. It's something that I've started to do, and but judges don't necessarily have to only do it sua sponte, meaning just by themselves. It could be tenants doing that, it could be tenants' attorneys moving for that. So that's one thing that I would encourage, number one, with regard to HRA. With regard to HPD, having been an HP part, my experience with HPD attorneys is I find them, and I see that we have Deborah Rand here, my experience has been they're very dedicated and they care deeply about the mission of maintaining housing standards in New York City. But one of the things that I have heard from HPD attorneys, and I'm saying this because I think there are people in the room who are organizers and advocates, is that they feel, I don't know if the word's pressure, I don't know if the word's, but they feel the impact of organizing, they feel the impact of, oh, we have a constituency that we have to respond to, and that's why we're advocating in this way. So to the extent that you're doing something that's causing attorneys, who I think are already pretty good at what they do, but causing them to be very zealous in their advocacy and maintaining housing standards, keep it up or increase it or keep doing stuff like that with regard to HPD.
I was just gonna add, in terms of processing, my organization, the Relay Society, has 2 outstanding cases right now where we've sued the city related to processing delays associated with opening public assistance cases. We also have litigation out there with the city agency. HRA is supposed to also help people get onto the FEPS program at the center, and they're pushing people to do one-shot deals. One-shot deals is by its name, it's meant to be a one-time thing, whereas FEPS is supposed to be ongoing assistance. So we are constantly monitoring those situations, and we sue them when we need to be able to try to hold them accountable for some of those problems, because it also contributes to advocates and attorneys' time to try to navigate through these systems. That's like half of what I feel like our attorneys and advocates do at our organization all day long, is trying to help people navigate through these systems, to expedite things or to make it work right. And if they worked right, or maybe they had better staffing, then maybe there would be ways to be able to do more cases. But the studies have shown that the time it takes to do this type of work includes all of that, and it is very time consuming. But hopefully, with more accountability and we'll keep doing that it will improve. We have seen some improvement, but it needs to get a lot better. I think it got worse as we have slowly come out of whatever we are now in this, it's not really post, but sort of after pandemic, I don't know what I'd call it.
Can someone speak about the eviction process as it relates to New York City marshals? We haven't spoken about marshals this morning. I know there was some recent reporting about salaries that marshals make. Why do they make so much money in the millions? Why are people literally profiting off of tenants getting evicted? Is there policy that can be crafted to change this?
I mean, I can speak very generally about it. You know, it's always struck me as a very corrupt system. You know, it's a bounty hunter kind of approach. And since when do you have a civil servant type job? You know, dependent, and your income dependent on how many. It says, you know, I mean, the police have their quotas. Lots of jobs have, you know. Housing court judges have their calendar, you know, obligations, but to pay people and allow them to earn income based on how many times they put somebody out of home seems to me to be absurd. And you know, it's definitely something that's worth doing a real serious investigation of an expose of how it's worked and why is it like this? Why is it the way it is? So.
How can a retired lawyer volunteer to represent the client? Anyone, who's gonna hire the retired lawyer?
Great, look at legal service provider websites, they have opportunities to volunteer, to be part of it, join in organizing. You can do a lot of work not representing people too. So it's not just about representation, but there's a lot of things and causes that you can do. I just want to plug one more time, like, we need good cause in New York. We need it. So to the extent people are willing to advocate and educate people on why it's so important, especially right now while we do have the system we live in, we need to have people who are part of that fight and join local organizations, contact local legal service providers, New York City Bar Associations. There are places to do this work. You do have to look for it and apply.
In my situation, I became a housing lawyer by doing pro bono for God of Riverside through my good friend Larry Wood over there, who introduced me to housing and becoming a tenant lawyer. So I'll always want to thank and give a shout out to my good friend Larry Wood over there.
Well,
And now constituent.
Okay, I'm gonna take one more question from the audience, and then I wanna give the panelists a final opportunity to say any closing remarks. But we have mentioned good cause evictions in this morning as a policy, as a piece of legislation that needs to be passed. There's a question here that is essentially talking about families that have lived in their apartments that are not subject to rent stabilization 10, 15, 20, 25 years, right? We see this a lot in the other boroughs. I remember when I was working with Make the Road in Brooklyn, you know, I had a client, two buildings looked exactly the same, except one was subject to rent stabilization and one was not. Two exact same neighborhood families that have lived in the neighborhood for 20, 30 years, right? And one will get to keep the apartment, the other one will lose it, right? And so I want to give the parents an opportunity to say anything that may not have been mentioned about good cause eviction and the importance of that piece of legislation to bring more rights, not only to rent stabilized tenants, but particularly for them that do not obey protections of rent stabilization.
So my answer was one question too early, I guess, regarding that. I mean, it's baffling to me why good cause is such a controversial thing. It doesn't mean that there aren't still rights on both sides, but it just makes it so that if you're a tenant who is basically paying your rent and complying with your lease, you get to stay somewhere that's been your home. I don't understand how that is so controversial, but it is. So talk to your local council member, assembly member, senator, like we need more people to come out and support this so that they know that this is not just like the New York City tenant advocates, this is like a statewide issue. So, and then what I said before also.
Yeah, I agree, and also so we've been fighting for good, initially we fought for good causes, part of the HSBPA, so it was one of the, I think it was like 9 or 10 bills that were on the docket in 2019, and that was the one that didn't make it through. And we've been fighting for it since then, and it's way weaker than actual extension of rent stabilization to anyone who's unregulated. That would be ideal, but as a policy, it would be really important and it needs to pass, but the amount of counter-organizing that we've seen from the landlord lobby has been staggering. So the reason why it's not passing is because RECME and CHIP and landlord lobby groups are organizing landlords who are calling their calling their state electeds, calling the governor, giving the governor lots of money to oppose it. So, yeah, I mean, we just have to counter organize against them. That's the only way that it's going to happen.
You know, the only thing I would add to that is that I don't think there's any reason to be surprised. You know, I think it's why the landlord lobby opposes rent regulation or any, you know, progress with rent regulation. And it really goes to what Sam was talking about before. You know, we need a system that actually prioritizes housing. You know, when I interview students for my clinic, I often have to like explain that this is not about real estate. You know, real estate's the term for the business. This is about housing. This is about people's homes and their communities, and that we need to change the framing, frankly. You know, and that's why there's, you know, it's hard to make progress in something like Just Cause, because it kind of, you know, it takes away the power and the control that people have over their business when they do it as a business. I think that's, you know, we have to understand that and find ways to deal with it.
Well, that's an interesting question, actually. Is there some alternative way to collect arrears other than litigation? I think one thing we haven't spoken about this morning is, are there ways where landlords could get paid without holding the threat of an eviction and homelessness in order to reach that result? Any panelists know of any other efforts to implement systems to collect rent other than taking people housing?
I mean, we saw that happen during the pandemic, right? Cases were not moving forward. Sometimes for at least a brief period of time, they weren't even able to file. I think certain agencies relaxing the requirements for some of these programs, which often have the requirement of having an eviction proceeding active and pending, and not just prospective and theory, I think that would help. You know, part of the city FEPS legislation and things like that, it would create a larger pool of people who would be eligible for these ongoing programs, which would make it less necessary probably to have like a one-shot deal, because they don't need a one-shot deal if you're on a program that helps make the rent more affordable. But it also gets back to the point of we need more affordable housing in New York City. But I mean, I think right now, the main reason is because the programs like one-shot deal through HRA or anything through, the city often require that eviction component. We've worked to try to minimize that so that you can do it with maybe a notice that you got before eviction cases started. And we've advocated with the city on these grounds. They have done it to some extent, but I don't think it's as widespread and that people don't know that they can do that. So maybe it's also an education component too.
All right, we are 5 minutes from time. I want to give the panelists final opportunity to just say any closing remarks, anything that you have not an opportunity to cover today that you would like to speak on. We covered everything.
I was gonna say, don't mean to hold you.
Premature applause.
I want to say that, you know, I have been around this work for 45 years, and there's never been a moment like this. I mean, I look out at this room, there's so many people with so much energy, with so much thought, with such great sort of strategic thinking about change, and it's really very heartwarming to see, and you know, I want to encourage people to think big. I mean, changes don't come about without organizing, without a vision for the way things need to be. And, you know, we just have to challenge, we have to disrupt, we have to have a big vision for where we're going. I think you heard a lot of that here on the panel. And, you know, I encourage you to stick to what you've been doing and keep growing this movement, which has been growing really enormously over the last few years.
Judge Stoller, Councilmember Abreu, Ms. Springer, Mr. Trump, Ms. Renova, and Professor Sharon, thank you so much. There were more questions than what I read, apologies for not getting to all of them, but feel free to moderate us. Thank you.
Is it?
We add those questions.
Okay.